Hello, ladies and gentlemen, good afternoon to you all. I welcome our panelists and you all audience. Sorry. So, I welcome our panelists and all our audience at this side event titled GDPR for SMEs and Experience of the ARC project. So I, Aswhinee Kumar, will moderate this panel and let me introduce our panelists. The first member is Ms. Iva Katić. Sorry if I pronounce it wrong. Iva has been working for the Croatian Personal Data Protection Agency AJOP since 2018 and represents the agency at several international working groups, example GPA, EKGDPR, and LED Group. Iva has been involved in the ARC project and twinning projects. Currently, she is working as Secretary to the Cabinet Office, Croatia. Iva will cover topics like accountability, consent, and data breach issues that we noticed have been very difficult for SMEs to manage. Second in the line, Ms. Pauline Hellemans. Pauline is a researcher at the Center of IT and IP Law at Catholic University Leuven, Belgium, and an IP and IT and Data Protection Associate at the Belgium law firm Lydian. Pauline has worked on the Boost project that focused on the implementation of the GDPR by SMEs. Pauline will discuss issues related to general awareness and the practical issues that SMEs are facing with in implementing transparency obligations by looking into the common mistakes of SMEs identified in the case law of Belgian Data Protection Authority and the findings of the Boost project and the speaker's normal practice as an attorney. Third in the line is Ms. Lena Jasmine, my colleague. Lena is a doctoral candidate at Vrije University, Brussels. She is a contributing fellow and the education coordinator at the Brussels Privacy Hub, where she explores topics such as legal implications of new legislative initiatives on individuals' right to privacy and data protection. She publishes on topics concerning protection of human rights, regulation of new technology, for example, digital identity wallets and artificial intelligence and cybersecurity. Lena's title of presentation is How Can DPAs Lead SMEs to GDPR Compliance? I myself am a PhD researcher here. My supervisor is here, Professor Paul Dehart. I'm a bit happy and nervous both because he's here to assist me. So first of all, I will present the ARC project result and then we'll invite our speakers to share their experiences. So you can see the panel, GDPR for SMEs, and experience of the ARC project. ARC is a EU co-funded project wherein VUB, Vrije University, Brussels, Data Protection Commission, Ireland, and Croatian Personal Data Protection Agency are partners. AZOP is a coordinator of the project as well. So our speakers will be Ms. Iva Ivanovic. I have introduced you, Ms. Pauline Hellemans, Ms. Lena, and me. The ARC project kicked off on 18th March 2018 and will finish on 31st August 2022. I have introduced the consortium members here. The ARC project performed a survey on SMEs. That result I am going to present before you. So the total number of questions in the survey that we put in is 83. And total number of SMEs participated in the survey is around 500, in which Croatian SMEs were 345 and Irish SMEs were 154. Nature of businesses of the SMEs participated in the survey. We have given a various business nature of businesses in our survey to see the kind of SMEs that participated in the survey. You can see security services and manufacturing, pharmaceuticals, marketing, and the list goes and goes until telco. So the biggest number of participants were from security services, who is doing businesses in providing protection to property and of course individuals. And the least were from telco sectors. Around 21% of SMEs did not find their nature of business in the list that we were provided, and they chose as heading others. Participation in the survey according to the size of enterprises. Of course, the project runs for SMEs, so small, medium, and micro business. So micro enterprises were the most to represent in the survey, that is around 50%. Small enterprises participated around 26%, and medium enterprises were 24% of the total SMEs participated in our survey. SMEs participate in the survey through, there are different management boards who participate in the survey to answer the questions, like directors of the SMEs were 37%, senior managers represented 22%, and DPOs around 21%, and others, they did not find their position in the previous list, they choose as others, and their representation was around 20%. The survey questions analysis were done under 9 different headings. We all partners have decided that we should not give questions randomly. We must categorize the questions in a particular headings. So we created these 9 headings with general awareness. It was about to find about the general awareness knowledge of SMEs regarding knowledge of their staff about obligation of GDPR and their understanding of data processing agreement, their awareness of role of compliance with the GDPR, and their need of training to provide to their staffs. So, and then policies for customers, transparency mechanism, security standards, accountability guarantee, legality and territoriality, monitoring while doing business, things about breach, and handling with in COVID-19. We especially created this heading because our project, when kicked off, lockdown just started in Europe. So we tried to find some sort of information about how the COVID situation will going to impact the business of SMEs, especially in regard to GDPR. Survey responses analysis under general awareness. So each headings we analyze the responses. So in general awareness heading, we created different questions on like awareness of personal data, staff's knowledge about obligations, training to be provided to their staffs, understanding the need of data protection agreement, awareness of role of compliance. So we analyze in a different manner that 0 to 60% if their awareness or knowledge are within the range of 0 to 60%, we found it that that particular topic or particular area are challenging for SMEs, and then we think that the risk possessed on that particular area will be the highest. Then good category if awareness reach the criteria of 61 to 90% of SMEs, then it is in good category, and the risk possessed will be under moderate. And then very good category if the awareness about a particular question or about a particular area is more than 91%, then we put it in low risk category. So on these 3 criteria, we assess the responses of SMEs. You can see on general awareness heading, and then survey responses analysis under policies for customers. In this criteria, we found that SMEs have a moderate kind of knowledge, especially enthusiasm of data protection policy. So if I'm not remembering incorrectly, 75% of SMEs say that yes, they have data protection policy and they are trying to have it more. And their staff's awareness about the data protection policy also found very well. In transparency mechanism heading, we found 2 criteria that SMEs needs to be encouraged, especially access requests granted. So at this heading, SMEs are facing a bit challenge because they know that there should be a right to access, but they don't know how to grant access practically. And then in having data retention policy, yes, this is the also heading where SMEs are facing the challenges the most because their awareness about data retention policy is very, very low. Regarding understanding of what to right to access is, yes, they are not in good, not in bad condition, especially they know very well about data transfer to third party, both within the European Union and outside the European Union. So these 2 criteria have been found difficult for SMEs, like how to grant right to access and what is about data retention policy. So I think Pauline will take care of it later on. Our next heading of survey is survey response analysis under security standards. And in security standards, almost they did well regarding their knowledge about availability of technology to protect data, restriction access to hard copy data. They managed at this level very well. Survey responses under accountability guarantee. This is the area where SMEs faces the most difficult situations. Like you can see the 1, 2, 3, 4, 5 red arrows. It means that almost you can see they didn't achieve the very good criteria level. At 3 level, they reach only to good level, but at 5 different criterias level, they didn't do well, or you can say they are facing challenges, especially having policy to deal with the right to request. As I mentioned earlier, they don't know how to deal with right to access, and then obligation to public privacy policy at this stage. Only, if I'm not remembered incorrectly, 16 to 70% SMEs say that yes, they know to publish, they are under obligation to publish privacy policy on website. Rest say they don't know about it. Their knowledge about record keeping was also not very good. And then 34%, around 34% SMEs say they do not require to appoint DPO. Some 27 or 28% say they don't know whether they need to appoint a DPO or not, something like that. And then they also struggling to have a good practice to perform data protection impact assessment. Then survey responses analysis under legality and territorial headings. You can see here they did not very good, not very bad, but yes, in midway. Their knowledge about legal basis, yes, of course, good. Knowledge about consent as a form of legal basis is good. But especially in a Croatian SME section, we found that almost more than 70% SME, they do not know if they collected or they have consent validly obtained from the data subject or not. So at this heading, Eva will take care of it. And confidence about how consent was obtained, yes, that I told you, they are not very confident if they validly obtain the consent from data subject or not. And then capacity to respond in case of withdrawal, yes, they know how to respond. Survey responses analysis under monitoring while doing business. This is mostly related to having a surveillance on staff's activities while they are under duty. So here we found it's almost good. They know how to handle about data surveillance. They are trying to let their staff aware that yes, we are doing surveillance on you, something like that. Survey responses under things about breach. Yes, things about breach, especially in section of having internal policy to deal with the data breach problem. So around 18 or 19% SMEs, they have only 18 or 90% SMEs have data breach policy. The rest did not have. Data breach happened previously, yes. SMEs experiences data breach previously. Assessment about previous data breach, yes, they did. Notification about data breach to DPAs, yes, they did, but Croatian SMEs facing a bit difficulty in notifying to data breach to DPAs. Communication to individual about data breach, yes, they communicated or they are trying to communicate if breach happens. Adjustment in existing data security standards to counter future data breach. They are trying to have policies and technology, advanced technology in their system to stop data breach in future. And they found DPA's attitude very good, very calm when they approach to them, and they say DPAs are really helping to them when they are notifying about data breach to them. Survey responses under handling with in COVID-19 includes, we provided different sections to them, like leverages provided to staff to work remotely. So SMEs have provided room to their staff to work remotely. They also provided remote access to data repository to their staff, but measure taken to secure data against, but they could not take simply good measures how to secure data if they provide remote access to their staff. understanding of special categories of personal data. They do have knowledge about special categories of personal data. They also try to have special measures to protect a special category of personal data, and they also have policies for purpose limitation. At least they know what is these things. Some important and interesting facts about our survey that we get: only 22% of the participating SMEs have shown willingness to be contacted by the ARC project team. The rest do not want to be contacted for so many reasons, because of having two DPAs with them. The ARC project survey has been dominated by SMEs participated to their female officers almost in every sector, like micro SMEs, micro enterprises, medium enterprises, and small enterprises. In all these enterprises, female officers have dominated the survey, as you can see in our panel. 37% SMEs believe that they are not required to appoint a DPO. I have mentioned you, and 23% are not sure whether they need to appoint a DPO or not. So this particular section should be taken into consideration, because both Irish and Croatian experience was not very good especially about SMEs on the aspect of having a DPO in their enterprises or not. And last, around 54% SMEs have not performed DPI. Yes, 54% SMEs have never performed data protection impact assessment. If you see, according to the size of enterprises, 63% of micro enterprises never done data protection impact assessment, 56% of small enterprises never did, and 31% of medium enterprises never performed data protection impact assessment. Last but not least, if you want to reach to the survey result, which is I think 54 pages long document, and you also want to reach to our educational materials, videos and promos and events, you may please go to this ARC project website, where you can find all information related to us. The language of information you can find in Croatian and English both. Thank you for being with us. And now I will invite our first speaker, Pauline. Pauline will take care of general awareness issue and transparency issue with SMEs. So Pauline, the floor is yours, please.
So as stated by Aswhinee, I worked on the Boost project. I don't have slides. I worked on the Boost project, which ran from January 2020 to December 2021, so it has finished a couple of months ago. The Boost project focused on the GDPR implementation of SMEs in Belgium, and we worked with the Smes at VUB, we worked with Kritz at UNAMUR, and City where I worked, KU Leuven, and with the Belgian Data Protection Authority. So those exchanges were very interesting. This project had three main themes. These were transparency, data protection impact assessments, and the roles of processor and controller. In the context of the project, we first conducted some research regarding the implementation and also the knowledge of SMEs of the GDPR, to then provide tools to improve the implementation of the GDPR. And in that sense, we established a FAQ brochure, so a frequently asked questions brochure that I drafted. We also made a data subject access request guide. We also provided templates, template letters that SMEs can use to respond to a data subject access request. And we also did a seminar last year where I spoke about transparency. First of all, I will shortly speak about some of the findings of our research, to then, after that, speak about transparency. And in the context of transparency, I will speak about the information obligations that SMEs and controllers have, and then I will also speak about data subject access requests. So first, regarding the research, the Smes at VUB conducted two surveys, one about the knowledge of SMEs and also one about implementation of the GDPR of the SMEs. This survey was conducted in May 2020 May and June 2020. And it's important to note that there were not enough respondents to have representative conclusions, but still some of the findings were quite interesting. I will just focus on two parts of the survey. One is general compliance, and the second one is the use or collaboration of third parties, because Aswhinee also asked me to talk about the third parties. Now, first, regarding the general compliance, most SMEs stated that GDPR was not a priority anymore. At that time, we were 2 years after the entry into application of the GDPR in May 2018. And so most SMEs did some superficial, basic GDPR compliance, but for them it was over. It was considered as something very burdensome, administrative, not very interesting. And so the only further compliance or implementation efforts that they would do was when a new issue would present itself, such as a data subject access request or maybe a data breach or something else. What was also interesting is that some SMEs considered that they did not have to comply with the GDPR because they did not fall within the scope of the GDPR, which is quite astonishing, I think. What also appeared was that most SMEs consider that they not have enough financial means and time to invest into the GDPR. Also, there is a lack of easily available and accessible advice for SMEs, so there's not enough guidance of the Belgian authority or the other authorities, and the law in itself is not clear enough for them. The only information they do have is the information provided by sectorial organizations, which in Belgium are very present. But the issue there is that not all SMEs are member of such an organization, and also the advice provided by these organizations is not approved by the Belgian Data Protection Authority, so there is still a lot of insecurity and also frustration regarding that, and also the GBA is not prepared to approve any of that guidance. Yeah, I think I said everything. And then next, the issue in collaboration with third parties. SMEs indicated that the collaboration with third parties and data processing activities is the fourth hardest issue regarding the GDPR, because although they have some basic knowledge about what the role of controller and processor is, in practice it's really hard for them to apply these concepts. They also do not even know sometimes who they collaborate with. They are not aware of maybe a hosting provider, or maybe that the email that they use is also a third party that they're working with. What was also interesting is that for the data processing agreements, most of them work with their own templates or with templates that they've received from external counsel, so they do not use, for example, the Danish data processing agreement or maybe other templates that are available online. And also what they find very hard is the negotiation of such agreements. On the one hand, with big IT service providers, for example, they impose their template, and so it's hard to know if they can negotiate such agreements. And on the other hand, it's also hard for them to impose or to oblige service providers to sign such an agreement. And so they don't really know how to implement or enforce such agreements. And so they ask tips on how to make a service provider execute such an agreement. And also what is hard for them is when they receive a template from a service provider or from someone else, it's hard to distinguish what is mandatory in the law of Article 28 of the GDPR and what is commercially added in the agreement. For example, the costs of the auditor who must pay them, it's hard for them to see which is which and what they have to accept and what not. Now I'll go over to transparency. Now, why did I choose the topic of transparency? I spoke about it in the Boost seminar last year, but also for the Belgian GBA, it's very important for enforcement, because on the one hand, they told us that for starting an inspection, they will look at the website of SMEs or companies, and if the policy is not compliant, then that will be a trigger to start an inspection. So it's very important that this policy on the website is compliant, and they even went as far as to not want to create a tool for privacy policies, because then this would take away a tool for them to start an inspection. It's also important because if there are issues with transparency, then data subjects may be surprised, may not be happy, and they may file a complaint with the GBA, which then again can trigger proceedings. Now, in our research, SMEs stated that they thought that they had a fairly good idea of what transparency was and how to comply with the obligations, but it also appeared that they didn't know some basic concepts such as the roles of controller processor, which are essential to be able to be transparent in a diligent manner. And so transparency is very interesting because you have to have a really good knowledge of the GDPR and be actually a quite mature organization in terms of GDPR to be able to be transparent in a correct and diligent manner. Now, to illustrate this, I thought I would look at some practical issues of transparency of the mandatory obligations of Article 13 and 14, which you all know, I'm sure, but are interesting to reflect this. Also, I will look for this to the Belgian case law of the GBA, which is interesting because these are practical use cases of the GDPR, and this is also a complaint that SMEs had. There is no practical guidance, there are no use cases, but actually now over 2 years later there are, because there is the decisions of the data protection authorities. However, I'm aware that this is not very accessible and it's very time consuming to analyze all these decisions. For example, Article 13 and 14, they state that you must provide the contact details of your DPO. But many companies, as you stated, they don't really know what a DPO is, how they should implement them, how they should decide to have a DPO. So an SME must have already had the analysis and thought about, should I have a DPO? Also, the Belgian DPA states that if you have a DPO, you have to indicate in your privacy policy your relationship to the DPO. So if it's an external DPO, you should notify this to data subjects. Also, Article 13 and 14 states that you must indicate the purposes of your processing and also your legal ground of processing, which again asks a pretty complex reasoning already and a far-going analysis to know what processing activities that you have and also what legal grounds that you use for these activities. So actually you should have a very complete record of processing activities already. And what we already also see in practice is that SMEs or even big undertakings in their privacy policy, they will give 5 alternative legal grounds of processing. So legitimate interest, consent, all different ones, and then sometimes one may apply and sometimes another one may apply. If the consent is not there anymore, then maybe they will use another one, and this is not compliant, at least not according to the case law of the Belgian Data Protection Authority. So again, this requires, already a big maturity. Also, for the concept of purpose limitation, if you're using data for one object or one objective, you must also be transparent and communicate to data subjects that you're using data for other objectives, and this must also be communicated. So again, this asks already quite some compliance. To link back to what I just said, you also have to state who will receive your personal data or who will be the categories of receivers of these personal data, and the Belgian GBA states that this list must be exhaustive. So you must know as an organization who will receive the personal data that you receive, and look forward in the future who will you transfer to. Also, if you transfer outside of the EU, you must also include this. And you stated in your research that apparently SMEs are quite aware of these transfers, but from my practice, I don't really have that feeling that they know that if they use Facebook, for example, that they know that data might be transferred to the US. Or Google Analytics now recently is an issue. Most SMEs are not aware of this. Aswhinee also asked me to talk about retention periods or retention policies. Well, Article 13 and 14 asks you to include in your privacy policy how long the personal data will be maintained, or the calculation criteria at least. So this means that the SME must have a retention policy to be able to include this information in the privacy policy. Now, I don't know if you've ever made such a retention policy, but I have in practice, and it's quite complex because you must look at, the way we do it at least, is we look at the prescription. How long do you have to keep data for proceedings? So immovable property, Belgium, for example, it's 30 years. But for an SME, this means that you have to do this exercise, have the means, the time, or the money to ask someone to do this for you. So it's pretty far going, and I think many SMEs are not that far yet. And then finally, I will not go into everything, you have to list all the rights of data subjects. So this brings me to my final topic, data subject access requests, because Aswhinee asked me to talk about it. I think it's important to have a policy in place or to be able to answer to these requests. And also in our survey, it appeared that this is quite difficult for SMEs because if something goes wrong with these requests, then this can result in a complaint with the GBA. And we see also that almost all case law of the GBA concerns in Belgium access requests or other exercises of rights. And it's also interesting because an access request or a request can reach anyone in the organization, and so it means that everyone in the organization must be somewhat aware of GDPR or must be able to recognize such a request. For example, someone asking to change its email address, well, it's a right to rectification, you must recognize it as such and answer in time. So it's quite difficult. Now, because SMEs had issues with managing such requests, we established guidelines regarding managing such requests, and we also provided template letters in French and in Dutch that can be used by SMEs to answer to such requests. And before I go into some parts of the guidelines, again, to be able to answer diligently and in time to such requests, you have to be quite mature in like GDPR compliance to be able to answer. So yeah, in our guidelines that we drafted, I think it was the VEB who drafted them, we state that you have to have systems and processes into place in your internal organization to be able to answer in time. Your records of processing activities must be really good and really complete to be able to answer within a month to an access request, for example. The GDPR also states that you can check the identity, or you should check the identity of the data subject that is asking you the request, but if you know the identity through other means, for example, the email address or the login into your systems, you cannot ask systematically for other identification means or an ID, and this is something that goes often wrong in Belgium at least. You must also facilitate the data subject access request, which is a bit vague. There is some interpretation in Belgian case law, but it's still very vague. For example, one case states that you cannot write in your privacy policy that before contacting the DPO, you must first contact the organization, for example. You must also answer within a month. And if you receive a second request, you cannot use that date of the second request to calculate the month. It's the first request that is important, and that's when the month starts. And also, if you ask additional questions because the request maybe is not clear, the date of the first request still is important and is the one that stays. However, what is very important is that the Court of Appeal, which is the appeal above the litigation chamber of the Belgian GBA, has stated that you cannot have a sanction for not respecting the delay of 1 month. And they have repeated this case law three times now, so I mean, it's pretty interesting, I think, because they state that Article 12 is not legally sanctioned, according to them. And then furthermore, we state again that you must make your employees or collaborators really aware of the GDPR to be able to recognize such a request. Now, I think that was everything from me, but I think the conclusion of what I was saying is really that to be able to respect these, so to say, basic requirements of the GDPR, you really have to have like a really mature organization already, and there the organizations or SMEs lack the necessary means in time or financially to be able to respect these obligations.
Now I will invite our next speaker, Ms. Iva. Iva will take care of accountability guarantee and issues related to how to obtain consent legally and validly, and then a data breach perspective, especially the importance of having the policy to deal with the data breach and the importance of notification about the breach of DPA. Breach to the DPA. In our survey, we especially found from Croatian SMEs perspective that they are very reluctant to grant right to access to the data subject, and also they were very reluctant to appoint DPOs. So Eva will tell, because our Croatian and Irish partner are doing consultations and workshop on the result that we found in our ARC survey. So Eva, I think you should tell better on the practical aspects. What is your experience of having DPA? Please, the floor is yours.
Thank you, Aswhinee. Hello, everyone. I'm Iva Katić from Croatian Personal Data Protection Agency, and I'm here to represent the Croatian DPA, which is a coordinator in the ARC project. So I'm really happy to be here. It's my first time on CPDP conference, and this is a very nice venue. We have a lovely romantic atmosphere while we discuss this important topic. Also here are representatives of the SMEs or academia, so the audience also is a kind of representing our project. Because this is a project about SMEs and how to raise awareness among them. I'm working on this project in the past 2 years, and I'm really happy with this role. It's few of us enthusiasts in Croatian DPA, along with our fellows in Ireland and VUB University. Why am I so happy? Because I prefer advisory role than enforcement role, because I think that the prevention of the breaches is the most important part of authorities, because when you prevent, there are no any breaches, no any financial or non-financial sorry, I got a bit confused. And when you enforce, it's really not so fun as raising awareness among SMEs. So SMEs are small companies, backbone of European economy. So I think it's very important to pay a special attention to them. So we kind of had more than 30 workshops during these past 2 years, and we plan to have only 16, so it's more than enough. Most of them were remotely done, but we also had some of them in live, especially in last few months. Some of them were specialized for tourism sector, for health sector, for marketing sector. So that's a very valuable thing that we have done. Also, the most important part, I think we made a lot of templates. This is the thing that SMEs wants the more. They want solutions and pro bono solutions. They don't want to pay for lawyers and consultants because they don't have money to do that. So we made a lot of templates who help the SMEs to comply with the GDPR. We made consent form, DPA form, legitimate test interest form. Also, we made a contract between controller and processor, a lot of guides on CCTV, which is very popular in Croatia, guides on data breach notification, guides on role between controllers and processors. So all this you may find on our ARC website, which you, Aswhinee, mentioned. And I want to say that in Croatia we have the first law on personal data protection we had maybe not even 20 years ago. So we are kind of a rookie player in the privacy community. So people are really struggling with complying with the GDPR, especially SMEs. So on our workshops, we saw really how people were advancing in their knowledge and how this was helpful to them. But still, there's a lot of to do because sometimes I discourage when we have a 2-hour session and we really try to do our best that people are more familiar with the GDPR compliance, and then we have a Q&A section in the end. And we have questions like, do I have to consent if I'm a new employee in a company and my employer wants to register me as an employee on health and pension insurance, which is a legal obligation of the company. So these kind of questions are still in. So sometimes I discourage, but this is why the role of DPO is very important. And people are, this is a Croatian experience, but I think that maybe among other countries the situation is the same. In the companies, people appoint a DPO, a person who has the less work to do. So there is some person who is not so important in the company, and then company says you will be DPO because someone has to do this part of the job. So this approach is very bad because DPO is a very important person. If you have a strong DPO, you don't have to pay for lawyers and for consultants to do the job that the DPO can do. Also, if a DPO is an important person in the company, he can raise awareness among the employees. From our experience, most of the breaches happened because of the human error. So I think it's a job of DPO to raise awareness among employees and in order to prevent this kind of events. And the last, which is connected with these human errors, is a topic of data breach report, which is also not so popular among SMEs. Probably because I think that mindset of the SMEs is if we report some breach, then for sure we will get some some fine. And we try to encourage people to report their breaches because most of them are not getting fined, and people can really learn from their own mistakes. That's about it. I think we don't have much more time. Right, Aswhinee? It's 5 p.m.
It's okay.
Now it's time to invite Lena to speak on her part. Lena's title of presentation is How Can DPAs Lead SMEs to GDPR Compliance?
Thank you, Aswhinee. Thank you for your kind introduction at the beginning of a panel, and thank you for the previous speakers. It was a very interesting experience to go back and immerse into the topics related to SME compliance. And in my presentation, I have 3 points that I want to discuss, and because we don't have a lot of time, I'll try to manage all 3 points quite quickly. So first of all, I'm going to talk briefly about the START 2 project that I had a great pleasure to work on between 2018 and 2020. And it was also one of the projects focused on raising awareness among SMEs and in this way leading them to better GDPR compliance. I will briefly touch upon a topic of what is an SME. It was not discussed today, and we all have an image of an organization or a company that is an SME, but I think it's not quite right. And that's why I will focus on this definition for a couple of minutes. And then I want to talk about ways in which DPAs, so data protection authorities, can lead SMEs to GDPR compliance. So STAR 2 project had very specific tasks through which we also obtained information in the field that was available. But as the project ran from August 2018 to 2020, so we got at the very beginning of a GDPR enforcement. And it was very interesting to work on this project because we worked together with the Hungarian Data Protection Authority, who was the coordinator of the project, and with trilateral research. And we received a lot of interesting insights that were not present before. And we also ran some studies and surveys, but they were not as impressive as an ARC. We didn't manage to get that many SMEs filling in the surveys at that time. I invite everyone actually to look at our output and the main achievements of the project that include the GDPR handbook, and we title the handbook "The GDPR Made Simple for SMEs." And as well, we prepared guidance for data protection authorities on how to run hotlines dedicated for SMEs specifically. And the guidelines were presented to the DPAs through one of the EDPB meetings. So that's quite an interesting, it was really an interesting work. And also have a handbook here. The handbook is available for download for free. And there are physical copies as well. But this handbook is slightly different from the other handbooks that are available because there are many materials right now on the facilitating GDPR compliance. In this handbook, we took a slightly different approach. So instead of explaining each concept that is included in the GDPR, we went through risk-based approach articles, and we tried to explain how, by implementing these articles in their context, they can be GDPR compliant. So, what is an SME? A definition of an SME is really broad, and I think it's quite a problem because we are faced with a definition that covers over 95% of all European companies, and it's just wrong. Because we assume that SMEs do not have resources, do not have money, do not have personnel that could lead to internal policies and procedures that are GDPR compliance. Now, I think what we should focus in awareness-raising projects are the companies that are of small size or micro entities, because these are the companies that really do not have these resources. That is to say that there are a lot of companies that fall into the category of medium-sized enterprise, but they are capable of devoting resources to being GDPR compliant. I'm not sure what is experience for Data Protection Authority when dealing with cases and investigations, whether this definition is of an importance or not. But maybe we can have a quick discussion about that. So basically, in our project that has been completed for some time now, we found that there are at least 3 ways that DPAs can lead SMEs to better GDPR compliance. And the first one is Hotline Service, and these services are provided by most of the European data protection authorities, And these include email queries, possibility to send email queries or to give phone calls and ask about particular situation of interest for SMEs, and in this way receive a guidance from a data protection authority. Now, this is of course very intensive process, and DPAs are required to respond in a certain time, and it's a heavy load for DPAs. Within our project, we had a special hotline dedicated to SMEs, and it was also promoted as such through radio campaigns and online. So there were only there were 2 people devoted for addressing questions from SMEs only. And after some time, we were able to analyze these questions and also we were able to get insight into the areas that SMEs lack knowledge of, or in which they would like to get knowledge, but they did not dare of posing inquiries. And what was interesting that while SMEs had a lot of questions about how to notify Data Protection Authority, they were not notifying the DPA, the Hungarian DPA at the time, that frequently as one could expect. The second way includes guidelines and brochures, something similar that Pauline talked about. And these brochures are based on frequently asked questions, and they can really save a lot of time for DPAs because they can answer these easy GDPR questions. And we know that there's no GDPR question that is very easy, like who is a controller, how to notify a data subject about the processing. But these brochures and guidelines documents can set some rules of the thumb, can provide certain examples that enterprises can follow. And the third way that came out through the interviews that we conducted with SME associations was that actually SME associations can be a middleman facilitating GDPR compliance. And we even advanced this argument further and published a paper explaining how DPAs could collaborate with SMEs, SME associations, in order to spread the word about the guidelines, about their interpretation. And the main reason why we suggested that this collaboration could work was that both SME associations and DPAs had the same interests. So it was in their interest to raise awareness about the GDPR compliance, and that was also expected from SME associations that are usually fee-based. So that's the first point. And the second advantage of DPA's collaboration with SMEs is that they have already established communication channels. And as Pauline pointed out in her speech, that sometimes not all organizations are part of SME associations, but there are some countries in which SME associations are very present. And these are, for example, Belgium, the Nordic countries, Denmark, Norway, Sweden. Of course, SME associations are not present in some countries because of a historical background. So, for example, in Lithuania and Hungary, SME associations are not that popular as a construct, but there are emerging entities that take place of an SME association. So there are these 3 ways that DPAs can lead SMEs to the GDPR compliance, and I think we can open the floor for a brief discussion. Perhaps, Iva, you want to follow up on that?
I think that the size of the SMEs is important to compliance because some of the provisions in GDPR are stating that you have to have something if you have more or less than 250 employees. So, for example, evidence on activities, it's depending on the size of the SMEs. Also, if you have more, it's not the same to have 1 employee or 241. I mean, you have definitely more processing, more data subjects, and etc. But sometimes SMEs that has only 10 employees can have more serious processings than other that has 250. If you are processing some sensitive data, or you are monitoring employees, or you are using some kind of advanced technologies like artificial intelligence or facial recognition, even in your company, then you can have more serious processing, and you need to follow up more on GDPR compliance than someone who has 250 employees and is doing some services like producing some materials or something like that. So that was the question about the size of SMEs. Yeah.
It makes me think when we were drafting the FAQ brochure, there is an exception to the obligation to have a record of processing activities if you have less than 250 employees. And we drafted this in collaboration with the GBA, and we wanted to include this exception in the brochure, and they actually didn't want to include the exception. And then we finally we were able to include the exception in the brochure, but we could not include an example of a company not having to make the record, because every example that we proposed was refused because they would still have to. They still had to have a record of processing activities, but even like really, we were talking about a plumber having his contact details in his computer, he still had to have a record. So it was very interesting to see that they were really hesitant to include this exception, and we were not allowed to put an example in. So, yeah.
Sometimes it's very hard to find examples, but this kind of processing activities are very good. That's something that I always say on the workshops. It's very useful to have for the company, because it's kind of an overview of, it's a scan of data flows in your organization. So if you're thinking before about what kind of data do you have, what kind of data subjects do you have, how long you are keeping your data, after what time you are erasing data, that kind of questions, you are kind of preventing breaches, I would say. Maybe some of the audience have a question about compliance in the SMEs.
Thank you for this presentation. I feel really privileged to have had the chance no, really, it was really interesting. So I have many thoughts, questions, and comments, but I don't think we have a lot of time. So maybe I will focus on 2 things. Well, 3. Very quick. One is that I think your project is very interesting and very useful. One thing that I was maybe a bit missing is that when you talk about SMEs, it's not just about the skill. I think I liked it when you came back to this discussion about plumbers, and so you have plumbers, and then you have AI startups, and I feel like it's not really the same kind of. I mean, if a plumber doesn't do a data protection impact assessment, I don't think that that's such a huge problem. But it might be if we're talking about a marketing AI, whatnot, wonderful company that is going to be the future of whatever. But that's just a thought. I have two. Oh yeah, of course. Then in the meantime, I can.
It's a great point. This is exactly why Lena said that it's a very problematic definition on SMEs. Because in Croatia, you have SMEs, IT companies, which are producing some serious IT softwares and solutions using all kinds of technologies, and they're in the group of SMEs. And you have some company who is not SMEs, and the company is doing some services where there are not so many personal data. So this is the exact point why the definition is so maybe even a bit absurd. And the project like this, it's very hard to implement because workshops are for all the SMEs. And then you have audience, you have plumbers, you have people who are, and you have, on the one side you have plumbers, and the other side you have these serious companies who are doing serious IT solutions. So you can cover all, I think, and this is why we made specialized workshops, but still it's not enough. I will return the mic.
Yeah. I am really in awe and that you actually managed to have so many SMEs, because I think it's not very easy when you're conducting research, and especially if you're a data protection authority and you go and see an SME and say, hey, tell me everything about your data processing activities and tell me everything that you're doing wrong. I guess it must have taken quite a bit of convincing, so really, like, hats off, because it's quite impressive. Anyhow, going to my two other questions. I have one question, which is a question of curiosity. I don't know if you have looked into it, but in the academic literature, there is a lot of talk about the privacy paradox, which has been also heavily criticized. I was wondering if you had any data or have looked at anything along the lines of how, because people working for companies, they might be working as for a data controller, but they're also data subjects themselves, probably with certain sets of preferences and ideas about what privacy should be. And I was wondering if that had any impact at all. And I will ask my second question together, because I think we will lack time otherwise. And it's with regards to the question of data retention periods. Because that one, in my experience, now taking off my academic hat and putting on my SME hat, is absolutely impossible. Because even if you say that prescription is, I don't know, 10 years for a certain thing. Now, in some cases, it's only a certain number of years after the person is aware that there is a problem. And so you cannot, it might happen in 50 years' time, right? And in some cases, the legislator might think that it is a good idea, and often it is a good idea, to say that prescription used to be 3 years, now it's going to be 5 or 10. And then you also have the problem, which is that imagine that somebody is litigating against you and that person is in, let's say, Swaziland, and you do not know the prescription times in Swahili, I think in English, criminal law, which you probably don't if you're a Lithuanian SME, and it's kind of hard to take into account. So there comes my question. Public bodies, as far as I know, and I've seen, kind of find a solution by having archives, because you can do archiving for the public interest. And so you can keep all of the data there, and it's not part of your active processing, and you can keep it. And so that's a great solution for public bodies. But private companies can hardly say that they're doing archives for the public interest. Yet, in some ways, it might be an elegant solution, although I don't know how far. I mean, there are plenty of question marks around it. And so, yeah, I was wondering if this is something that you had looked into or heard about or had any ideas on how we can solve this, especially considering that even if you're not talking about prescription and stuff like that, some companies might want to keep historical records, except they're not archiving in the public interest, so maybe there's legitimate interest, but anyhow, this is just a question about archiving and if this is something that has come up on the field.
I'll pass microphone to Pauline.
For the second question, yeah, I mean, I've only looked into this at the practical side as a lawyer, so we're limited to the questions that we receive of clients, of course, and the data retention policies that we have made have been limited to the prescription periods. But even this is awkward because one personal data may be, I mean, it's maybe one document that is relevant for 5 purposes, and so every purpose will have another retention period. So that's awkward indeed, and we only looked at Belgian law. We were maybe a bit short-sighted. What I have seen in practice is that where there is an issue, maybe a potential litigation in the future, then we keep the data under that purposing ground. This was also these were medical data. So then, but there we were also saying to the client, even though we have not really any case law to go on, like to base our advice on, this litigation must really be invisible. It must be really concrete already, because otherwise it's a bit complicated. And I think otherwise the advice would be to, if it's possible, anonymize and take out as much as data as possible. But as you said, for historical archiving, it's quite difficult. So it's something that I would have to look into further.
So before I conclude this session, let me do 2 things. First, I would like to thank you very much, Olga Gotakospolu, for helping me in organizing this event, because I was very late when I was planning the event and I had no administrative information what to do and how to do. But really, Olga advised me on each and every aspect how to do it. Can you imagine that even I texted her yesterday night on 11:30 or around 12 o'clock, and then she replied. Yeah, yeah, that nobody's do this, and I really planned. So thank you very much from the bottom of my heart, Olga, for doing this. And now I will request my audience to please go to the website that I told you about, the ARC project website, that is www.arc.project.eu. You will find each and every information about our videos, about our DPA's consultation and workshop materials, everything you will find on there. And you will also find our public deliverables there. I think all deliverables are public in this project, so no worries, please go. And now I will thank all my panelists to be here in such a short notice. Thank you very much.